Good morning. Welcome to the Utah Court of Appeals. We will consider three matters this morning. We will reconfigure the panel for our 11 o'clock matter, but the first of the matters we'll hear with this panel is In Re JM. And I think you've all been here, well, I know several of you have been here many, many times. It's nice to see you all again. Who will be arguing for appellants?
Me, Your Honor, Jason Richards.
Okay, and have you argued before, Mr. Richards?
I have.
Okay, very well.
Not as extensively as my colleagues.
Yes, understood. But I won't rehearse the whole rigmarole if you've been here on prior occasions. I'll just remind everyone that it's important that you not stray away from the microphone when you're arguing, because we live stream the proceedings and also record them, and occasionally want to go back and hear part of the argument. And if people have walked off to gesture, get files or such, we don't hear what you're saying. And with that in mind also, it's important each time you come to the podium that you state or restate your appearance for the record so we know who is saying what when. Anything else that should be mentioned? Very well, then whenever you're ready, Mr. Richards, we'll hear your argument.
Good morning. Jason Richards and Alexander Marshall for the mother. This appeal is primarily about the legally recognized method to set aside a child welfare adjudication order that was entered after parents make answers pursuant to Rule 34E of the Utah Rules of Juvenile Procedure. So parents in this case entered Rule 34E answers to the petition filed by DCFS primarily in order to get reunification services for their children. At the time of the disposition hearing, DCFS did an about-face and recommended no reunification and a goal of adoption. Parents were shocked by this. At this point, Parents Council realized that there's a big problem. So parents move orally at this disposition hearing to withdraw their 34E pleas. The court ordered the parents to file formal motions, which were done a few days later. A few days later, Mother's Counsel files a written motion titled Motion to Withdraw 34E No Contest Plea. That's it, record 1686.
Mr. Richards, can I jump in
Yes.
with a question? You've pleaded this as an ineffective assistance claim. And to show deficient performance, you would need to show that defense counsel acted incompetently under prevailing professional norms. Do I have that right?
Yes.
One of the things that struck me from the briefing on this is that both sides seem to agree that there's not a lot of settled case law about the mechanism by which we should be, the juvenile court should be considering motions to withdraw Rule 34E answers. Fair?
Yes, there's not a lot of cases.
Okay, so if there's not a lot of case law, if we're looking at this through the prism of the ineffective assistance doctrine, how could we say that defense counsel performed deficiently by not doing a thing that both parties are telling us is not settled either way?
In my opinion, it's not settled case law because the rules very clearly address this. So Rule 2 of the Juvenile Court Rules of Procedure clearly state that child welfare cases are to be governed and handled by the rules of civil procedure. Rule 48 of the Utah Rules of Juvenile Procedure address post-trial motions. A motion to withdraw a plea is in the delinquency section of the Utah Rules of Juvenile Procedure.
I mean, but you've told us in your brief, I think, I don't want to put words in your mouth, but I think you told us that a lot of attorneys are referring to these as Rule 34E pleas anyway, right?
That's colloquially how it's referred to.
It's colloquially how we're done. And the state in its brief has given us a string cite at one point at which it's citing various appellate cases in which courts seem to have been addressing these under the knowing and voluntary standard. So if there's at least a practice norm of doing this under the knowing and voluntary standard, even if you've persuaded us that reading the rules differently, perhaps it should be done under Rule 60B, how would we say under an ineffective assistance case law rubric the counsel should have known to do the thing that everybody else is doing differently?
Well, it's referred to as a 34E plea. That is true. I do not think it is the prevailing professional norm to file a motion to withdraw a 34E plea. I do not think that's within the realm of what a competent attorney would do in a child welfare case.
What would they do?
They would, well, first you have to deal with the adjudication order. So you would have to file, and I've done this as trial counsel, you file a motion to set aside the adjudication order. And
What
you
if
have,
you wanna withdraw them before the adjudication?
if you want to, so if
That would actually be better.
that would be much better, because you could just file a motion to amend your answer under Rule 15 of the Utah Rules of Civil Procedure. So, and those motions, there is an abundance of case law that have evaluated that process, and those motions are to be granted liberally.
Here-
This is,
oh.
sorry, this is true, that the rule itself, or the case law establishes that those are to be granted liberally, but I think if you're going to say, well, I'd like to latch on to Rule 15, then you need to latch on to all of it. And that body of case law also says that there are circumstances where the trial court should look, or often do look askance, and the appellate courts agree with that askance look, that if you are trying to amend, for example, in the face of a motion for summary judgment, we're not impressed. If it occurred to you before something happened, oh goodness, I need to amend my answer, then great. On the other hand, if the other side, based upon what you've said, moves for summary judgment, then all of a sudden you say, oh goodness, well, I want to amend, then that's too late. And clearly, after a judgment's been entered, if the summary judgment's been granted or some other dispositive actions taken by the court, that whole business about freely given's out the window. Don't you agree in the case law?
I would agree, yes, that's how the case law addresses amending
And
answers
so if we're
in
gonna
typical
import it,
civil
we would
cases.
import that as well, right? That if, you see what I'm getting at, is if you make
Sure.
these answers and you have buyer's remorse, and the next morning you file something with the court saying, I wanna withdraw, that might make sense. On the other hand, if, as in this case, you're like, wait a minute, if you're gonna take my answers and that's where you're going, that seems to be a different footing under Rule 15, doesn't it?
Rule 15 is not well suited to child welfare cases, and I think all of us agreed with that in our briefs, just because
True, but
adjudication.
you just told me that Rule 2 says that we have to follow the rules of procedure, so.
Well, it does, and that's why I'm saying to address this the proper way, and we really don't know because it wasn't handled properly. The answer resulted in an adjudication, and so that order has to be dealt with. The order has to be set aside.
But you're not suggesting, because I see where you're going with this. You're saying, no, let's go ahead, let there be an adjudication, then we're gonna use Rule 60B to try to undo that. And it seems to me that within there, that has a kernel of something that's a little bit distressing, is let's let it go to adjudication and then fix it, even if we realize there was something prior to adjudication which we should have done. Does that make sense, what I'm asking?
I don't know if I'm entirely
Not
making the
that you're-
connection.
Well, you seem to be saying that the proper procedural mechanism is Rule 60B. Rule 60B presumes that the court, there's been an adjudication, the court's ruled on something. There's
Sure.
either a ruling or an order or a
Correct.
judgment to be set aside, that's what Rule 60 is all about.
Yes.
But that begs the question, if a party does or should realize that there's a reason for them to try to withdraw these prior to the adjudication, prior to the order being entered, shouldn't there be a mechanism for them to do that?
I think there should be, yes.
And you're saying
Well,
that there isn't, well, you're saying either there isn't one or Rule 15 is all we've got, but it's ill-suited.
it's ill-suited, and I can tell you that what I think should be the process. I mean, that's absolutely, and that is exactly what I think Judge Tenney is getting at, that the prevailing norm in the juvenile court is to treat a Rule 34E plea answer like a criminal case. That's how it feels. I mean, often the juvenile court, as in this case, is informing the parents of all of their rights, making sure they know what they're doing, that they're not on any medication that impairs their decision-making, just like you would when you're taking a criminal plea. The key difference, though, is that in a criminal plea, Rule 11 of the Utah Rules of Criminal Procedure outlines an abundance of protections for criminal defendants. Primarily, you know what you're getting. The plea bargain is on the record. I mean, you know exactly what's being offered in exchange for your 34E or your guilty plea or your no contest
But
plea.
you-
That doesn't
that's not-
exist here.
That's not necessarily true. You can bind a district court to its disposition, what they're gonna do at sentencing. That is true. But universally, number one, you don't have to, and number two, that's not what happens. Many criminal defendants, the vast majority, enter pleas understanding what the sentence might be,
Sure.
but given the sentencing rubric we have in the state, there is a wide variety of what actually might happen.
I agree.
And as our cases show, there are plenty of defendants who, after they get sentenced, say, I want to withdraw my plea, and we uniformly say, too late.
Right. The difference here, and what does exist in criminal cases, is you have the prosecutor agreeing to something. So if the defendant and the prosecutor agree to a sentence, and then you get to sentencing, and the prosecutor reneges and doesn't follow through with his or her recommendation, then the plea is null and void. You can void that plea. And that's what didn't happen here.
But this is what I'm struggling with, and this comes back to my question. Everything you're saying makes sense to me on something of a pragmatic basis, but what I'm struggling with is that we're looking at it through the lens of Strickland. And Strickland tells us that there's only deficient performance if there's a violation of prevailing professional norms. And if we don't have a settled rule that addresses this scenario, and if everybody's kind of fumbling around in the dark, doing what they think makes sense, and you're saying, well, it makes more sense to do it this way, and some collective of attorneys are doing it a different way. How do we write the opinion that says that under the deficient performance prong of Strickland, counsel acted in an objectively unreasonable manner for not seeing your version of the unwritten rule versus their version of the unwritten rule?
Well, clearly, I think, and this is in my view, reading all of the briefs of the parties, except perhaps some of the language in the states, is that this is not the way you undo a 34E answer.
But if we don't have a case or a rule that says this is the way that you undo a Rule 34E answer, then how do we say to defense counsel in this case, you were incompetent under prevailing professional norms for not understanding what you should have done?
The AG in the juvenile court realized this right away in his responsive memo. I mean, that you cannot. A Rule 34E answer is not a plea under our prevailing rules. I mean, it's quite obvious. And you read through the Utah Rules of Juvenile Procedure, Rule 25A only applies to a delinquency
Well,
plea.
but what I understand, and correct me if I'm wrong, what I understand the juvenile court's response to that to have been was the following. Yes, it's true that this is a civil proceeding. It's governed by the civil rules to the extent that the juvenile rules have a gap. But even under the civil rules, I'm going to import the knowing and voluntary standard. And so the juvenile court seems to have picked up on what you just said and said, we're going to do this as if it's a civil rule proceeding. But the standard that I'm going to use in the context of this civil rule proceeding is the knowing and voluntary. So where's the error there?
Well, that's not the standard.
Says what?
Says, knowingly involuntary applies to criminal cases, not to civil cases. And so to undo, to set aside an adjudication order, you have to do it under 60B, and you have to raise the claims under 60B. And those claims, Judge Orr.
I'm with you to a point. I follow the logic that the better practice would be you find 34E admissions that, what was I thinking? I was confused, I didn't get it, there's been no adjudication yet. I want to undo that. So you move to withdraw those answers and file a proper answer going through admitting and denying and so on. Maybe the court grants that, maybe it doesn't. If we go clear to an adjudication as we did here, based on the 34E answers, then what we must do is first move under Rule 60 to set aside the adjudication insofar as it was based on these flawed admissions. And then answers, the 34E answers / admissions, but you've got some splaining to do at that point.
Yes.
And you've got to do it in timely fashion. And perhaps it's ineffective for counsel not to say, wait a darn minute. We were misled. We thought we had a deal that there were going to be reunification services, et cetera, if we were to do the 34E answers. We've been blindsided. That adjudication order should be set aside. Maybe that was ineffective. my big problem with what's happened here is that the time to address that is in the appeal from the adjudication order, which is itself a final order, and your one and only fuss is counsel was ineffective in not doing that. To deal with that after the entry months and months later of a separate final order seems to me exceedingly problematic, which is why we, perhaps not as artfully as we might have done, invited briefing on this particular aspect of the case. At what point in time should this ineffectiveness have been raised? It strikes me that the answer to that is not, well, at any point in time, including when we're appealing 8 months later, or however long it was, many, many months later, when we're appealing the termination decision. That seems to me way too late to be raising ineffective assistance that occurred prior to a separate final order. And I'm sorry for the rambling nature of the question. It's really more of a concern, but help me understand how it's timely for this to be raised now in the context of an appeal from the termination order rather than an appeal from the adjudication order, which is itself is a final order.
Sure. So, yeah, the child welfare cases, final orders are one that end the current child welfare proceeding, leaving no question open for further judicial action. So typically that's 15 days after the appealable order, and I recognize that an adjudication of an underlying custody petition typically is a final and appealable order. First, you have the problem of the ineffectiveness of the trial counsel. I mean, they're ineffective in not filing an appeal at that point of the denial of their motion. They should have, and it wasn't done. So expecting
Is that your claim on appeal, though?
that they should have filed a notice of appeal timely.
Yeah.
Well, it's two parts. It's they didn't file the proper motion, and then they didn't appeal the denial of that motion. So it is a claim on the court. I mean, the court invited us to address that, and so we have addressed that in our ineffectiveness portion of our brief. So it is ineffective. But finality in child welfare cases is not exactly like clear cut, because I understand adjudication orders typically must be appealed within 15 days, but typically what the case law says for finality of orders is what affects a permanent status in the custody of the child. These children had already been adjudicated.
But given the somewhat unique context in which we're looking at this, why wouldn't we take that language that you just quoted, which does come from our case law, and why wouldn't we say that insofar as we have already recognized that an adjudication order is a final order, and what you're really doing here through the ineffective assistance claim that you're raising is collaterally challenging the adjudication order, why wouldn't we just take the case law, sort of add it to that, and say, if you've got a motion to withdraw the Rule 34E answer, the denial of that likewise is a final order because it sort of ties into the same thing driving finality for purposes of the adjudication order. So therefore, you've got to appeal that within 15 days. Why wouldn't we just say that as a matter of sort of judicial gloss on the whole thing?
Well, it certainly would work for future cases to say that, but it doesn't work here. It doesn't work for.
Why wouldn't it work analytically? I mean, I'm trying to figure out how we would write this thing, and both sides seem to have recognized that we're in something of a conundrum here, that this is a really goofy scenario. And why isn't that the answer to this, is to just simply say, look, we've said that adjudication orders are final. What you're really doing if you file a motion to withdraw a Rule 34E answer that leads to an adjudication order is you're challenging the adjudication order. So therefore, that is also a final order from which you have to appeal within 15 days. Why wouldn't we say that?
And you could include in that appeal the ineffective assistance of counsel claim.
Well, it certainly would clear things up. I mean, I'm not disagreeing that that should be done, but the issue here is these cases are fluid. I mean, they do not just end. And what happened here too was that our client did not get reunification services, and that is not an appealable order until termination. That's when we can appeal that decision. And so those two things are combined here. The problematic adjudication where mother wanted to retry, to actually be heard on what happened and why her kids were removed from her care and into custody. And rather than be heard on that, she was denied that opportunity. And so that denial prejudiced her throughout the whole case. That there's 2004 case, In re AH, not the most recent one, but the 2004 AH case where this court reversed a termination order because the father, a non-custodial parent, was not served with an underlying custody petition. And there's some really good language in that case that says the reason why like the service of the termination petition did not cure failure to serve the original custody petition is that we can only speculate as to what would have happened had father been properly served. And that's the case here too. We can only speculate what would have happened to mother if she actually would have been heard at the time of adjudication. Maybe the court would have been more sympathetic to her. Maybe the court would have given her reunification services. I mean, this is not a severe abuse type situation. This is a neglect case.
If we conclude that the denial of the Rule 30, if the motion to withdraw the Rule 34E answers should be treated as final order, at that point, we don't have jurisdiction to even get to the IAC claim, do we? I mean, doesn't that stop the analysis?
If you find that the appeal wasn't timely taken?
Yeah.
Well, it's wrapped into the ineffectiveness. I mean, if counsel cannot assert their own ineffectiveness.
But even an ineffective assistance claim has to be part of a timely filed appeal. So if we answer that threshold question that's been posed by the supplemental briefing order, I don't know if it was a supplemental briefing order, but if we answer that threshold question that way, we don't then have jurisdiction to get to the ineffective assistance claim, right?
I think if that's how you answer it.
Yeah.
But I don't think that is accurate. I don't think that's a correct reading of the law. I think that because these cases are fluid, and if counsel's ineffectiveness came after the adjudication order, it came in doing things improper to challenge the adjudication order, and that same counsel remained on the case until about halfway through the termination proceeding when new counsel appeared. And so I think that's problematic, because if counsel's ineffective and didn't do things properly, then our client gets no justice, gets no recourse.
Well, my problem with, and you're right about the fluidity of these proceedings, but I don't know that that's another way of stating my earlier concern. I'm not sure that it's so fluid that once down the road we have a final order that we can go back and revisit. Sure, as per your notice of appeal, we can revisit the interlocutory orders that culminated in that final order, but I'm not sure it's so fluid that we can go back and revisit things that happened before an earlier sort of self-standing final order that has its own right of appeal. I'm not persuaded that it's that fluid.
And we are not seeking a remedy of reversing the adjudication order. I mean, the remedy we are seeking is reversing the termination order and either ordering the juvenile court to handle the motion to withdraw the plea or set aside the adjudication order, amend the answers, whatever we want to call it,
What's the daylight between the two? Because if you get the relief that you're seeking and your client is allowed to withdraw a Rule 34E answers, and those answers are the predicate for the adjudication order, then aren't you by definition asking the juvenile court for a reversal of the adjudication order?
Well, procedurally, that's not what we're seeking. Procedurally, we're asking, and I don't think this court has to like render to the juvenile court and say, you have to allow mother to set aside her adjudication order. I think the court can say, this was not handled properly, you need to address this, either through an evidentiary hearing. Let's talk about what the parents were offered in exchange for their answers. Let's talk about what their understanding was.
In other words, I don't want to put words in your mouth, but in theory, if we remanded in the manner you're suggesting, the juvenile court could look at it and deny the Rule 60B motion. You're just saying it needs to consider the Rule 60B motion.
It needs to be briefed, argued, and addressed the proper way, and none of that happened.
Right. So in theory, if it then at that point denies the Rule 60B motion, it would not then necessarily be undoing the adjudication order.
Correct.
Okay, thank
Thank
you
you.
very much. We
Thank you.
appreciate the argument. You'll have your full rebuttal time since it was our questions, especially my very long one that put you over your time. We'll hear from the other side.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor children. The present appeal is from a termination order. It is not from the adjudication order. It is not from the order denying what essentially was 60B relief, which was embedded in the disposition order.
Can we just start with the timing question? Explain to me how a denial of a motion to withdraw a Rule 34E answer would be a final order that would trigger an appeal time.
explain to you how a motion to
Yeah,
deny? Well,
let
we
me
don't have-
ask
first
it
of all, we
again.
don't have
Let me
that.
ask it again. Well, right, but so if you have to appeal within 15 days of a final
Right.
order, and everybody understands that two things qualify as final orders here, but the problem is that we're in the middle, right? The first thing is an adjudication order, which
Right.
is a final order.
Right.
And on the back end, you've got a termination order, which is a
Right.
final order. But what they're telling us in the briefing here, the problem in this case is that what they're trying to appeal is the denial of a motion to withdraw the Rule 34E answers, which happens in the middle.
Okay, and
So
that
if,
essentially,
so if it happens in the middle, it seems to me that you need us to say that that's a final order, which is why they had to appeal within 15 days, because if it's not, why don't they get to wait for the termination order?
exactly, and the judge essentially treated it as an order on a 60B relief, and a 60B order is a final order. They did not appeal that.
So in your view, is that the answer, is that we would write
That's
an
the-
opinion saying that a denial of a motion to withdraw a Rule 34E answer is a final order?
It wasn't okay, there is no 34E answer once you have an adjudication, which is what you had in this case. So the only remedy possible that they had was to set aside the adjudication order, and that's how the judge read it. And the judge essentially provided 60B relief. I'm not gonna set aside the final order. So they could have either appealed the adjudication order or the 60B order. They didn't appeal either one. So that's,
Are you, just to make sure I've got your position right, are you saying that when the court denies the motion to withdraw the answer, that resets the timeline for appealing the adjudication order?
I'm saying the court did not deny a motion to withdraw an answer. I'm saying the court denied a motion to set aside the adjudication order.
Okay, so using your framing then, I'm trying to
Okay,
get to a particular
okay,
answer.
okay.
Using that as the framing, are you saying that decision reset the timeline for filing the notice of appeal?
That's a separate final appealable order.
That's a
60B.
okay.
Yeah, it's a separate final appealable order. So they had two opportunities to appeal. They didn't appeal either one, and now they want to appeal the termination order. Now, the only case they can point to where this court has reached a prior final order in an appeal from a termination order is the 2004 case of In re AH. The problem with doing that is that In re AH never considered its own appellate jurisdiction to do what it did. And so I would say In re AH substantively is good law, but procedurally it is not good law. And I provided this court with cites from both the Court of Appeals and the Utah Supreme Court where it said you cannot reach claims arising from a prior final order in an appeal from a subsequent final order, even if all the equities and due process and whatever are just egregious. And I would say the most egregious case I can think of is In re Adoption BB, 2017 Utah 59. Now, that case is tricky to read because the majority opinion toggles between Justice Himonas, what he wrote, and Justice Lee's opinion. But paragraphs 102 to 107 deal with this very issue. And in that case, father appealed a motion an order denying his motion to intervene in an adoption proceeding. But there were ICWA issues in the termination of mother's rights. And father had no opportunity to even participate in that case because mother lied about the identity of the father. So we have some real equities on this. However, the Supreme Court said what father should have done in his motion to intervene is to file a Rule 60B motion seeking relief from the prior termination order.
Okay, but
Because he did not do so, they said, we have no jurisdiction to even reach that.
Okay, but this is a little bit tangential, but it's one of the points that they've stressed in their brief about this sort of broader problem, which is they're saying one of the things that makes our case different is that they're trying to do this through the lens of ineffective assistance. And there's all this case law, it's a little bit fuzzy at times, but it talks about how counsel's not required, or at least not obligated, to raise their own ineffectiveness, right?
Right.
So one of the things that they're telling us that makes this case different is that they're trying to raise what people seem to think should have been a Rule 60B motion, but they're trying to raise it through the lens of ineffective assistance. So how is counsel at that moment supposed to assert his or her own ineffective assistance at that moment? Because they're telling us that that's the reason this should get delayed, is because in order to get appointed counsel to raise the IAC claim, they've got to wait till after the termination trial.
No, they could have appealed the 60B or the adjudication. And upon appeal, they would get brand-new counsel who could raise that issue, but they didn't do that. And if we go with what they say, then no order is ever final in the child welfare context, and no child can have timely permanency. And if there's any context where we need timely permanency, it's in this case. And this is an appellate jurisdictional issue.
So how does that work? I apologize if this is too basic a question, but they're represented by an attorney in the juvenile court proceeding. They appeal from, you and I have disagreed a little bit about the terminology, but they appeal from the denial of the new attack on the adjudication order. They request appointed counsel to raise the IAC claim in that appeal. So does that mean by definition that the counsel who's currently representing them at the juvenile court proceeding has to withdraw at that point? You've got parallel counsel, one of whom is asserting ineffective assistance of the other one?
Well,
That's
the
the
one-
conundrum that they're pointing to.
Well, the one counsel could remain on the case for the disposition and termination, but you have fresh counsel on appeal who could raise the ineffective assistance of counsel claim and could advise the trial attorney whether or not he or she should withdraw. But this is an issue of this court's jurisdictional ability to reach a claim. That's how basic this is. And this court cannot reach that claim under all the case law that I cited in my brief. And I hope that you ask me a lot of questions because Mr. Peterson disagrees with me on this one. And I think it's the most basic question we can ask is whether or not this court can reach those claims in an appeal from a termination order when nobody appealed the 60B order, nobody appealed the adjudication order.
We perceived that problem when we asked for briefing in that particular. At what point in time can the ineffective assistance be raised if it pertains to entry of the 34E answers and the adjudication order?
And I would say you do that in the appeal from the adjudication order or an appeal from a 60B order.
And
That's
not months and months later in an appeal from the termination order?
No. This court would have no jurisdiction over a claim arising from an earlier final order, even under the guise of ineffective assistance of counsel. Otherwise, no order would ever be final, and otherwise it would totally upset all the case law going to the extent and the reach of this court's jurisdiction. If there are no other questions, then I'll cede my time. Thank you.
Thank you. We'll hear from the state.
May it please the court, John Peterson, Assistant Attorney General on behalf of the state of Utah. To start out, I'm kind of noting what I think Judge Tenney stressed all along is that this, it's a strange case. I mean, it's because basically you've got practice which is kind of developed on an ad hoc basis over years to kind of fill a void for rules that don't really exist. And it'd obviously be better if we had a rule, somewhat like Rule 11 of the criminal procedure, but we don't. And so over years, people have started using 34E effectively as a plea. Well, technically it's an answer. Normally what happens in practice is you enter your admissions pursuant to 34E, the court finds things are deemed admitted, and then adjudication occurs almost, contemporaneously. It's rare that you'll enter a 34E admissions and then weeks or months later, there'll be a adjudicate. I mean, it's almost always gonna be a contemporaneous event. But essentially, in this appeal, they've suggested that somehow there's two paths, obviously.
One of the things that Mr. Richards told us in response to some of the questioning was that there is, if I heard him correctly, that there is not a prevailing professional norm to file a motion to withdraw under a criminal procedure rubric. Do you agree or disagree with that?
I would disagree. I would say that, for all my years of doing this, which are plenty, this is the way things have been done. And we talked about 34E pleas. People call them 34E pleas. That's the nomenclature.
But in response to that point, he told us that even though they're being colloquially referred to as Rule 34E pleas, that when it gets to the withdrawal motion, that people are not commonly doing this under the sort of the same standard that's used in the criminal context. They're attempting to, withdraw a 34E plea or admissions. I would say it's not something that happens a lot. It's not like something that's happening in every case or even often. It happens, and I think as you correctly noticed, there's been some inconsistency. As we noted in our brief, even like IADD, who are presumed to be fairly knowledgeable in these matters, have filed pleadings suggesting all kinds of different standards, including the old criminal standard, but then they changed the criminal standard, so they don't like the new criminal standard, which was now knowing involuntary as well. But, so clearly, as you correctly noted, it's difficult to throw counsel under the bus where there's an unsettled, at best, area of the law, or alternatively, that they did it as best they could under prevailing norms. I think one or the other is true, but I don't think you can find that there is a clear... At bare minimum, we can throw counsel under the bus for the first problem, which they've identified, which is the counsel seems to have thought that this could be done under the rules of criminal procedure, even though Rule 2 of the juvenile rules says, no, this is not a criminal procedure problem, this is a civil procedure problem. So we can throw counsel under that part of the bus, right?
Oh, I think counsel, since there's not a really an identified manner, the next best thing, which seems to be, well, we could do it the same way they do it in other contexts, where.
Yeah, right, but I didn't mean to be flippant about that, but they're telling us that that's the point of divergence at which this case goes off the rails, which is that if counsel doesn't understand at the outset that this has to be done under the civil rules as opposed to the criminal rules, counsel then frames this incorrectly for the juvenile court. The juvenile court then analyzes it incorrectly. We're just in the wrong analytical place, and that's what they're saying is the problem. So why are they wrong about that?
I guess as we noted in our brief, I don't really understand, how functionally the court's analysis, as it did it in this case, would have been differently had it been a formally filed under Rule 60B. All the things that they're,
Do you think it's true that there's any daylight between the knowing and voluntary standard that applies to a plea withdrawal case and the mistake analysis under Rule 60B1? Is there any daylight between those two?
They don't seem to me to be functionally that different. No matter how you rate, whether their claim is that I was duped. We had an agreement, and all of a sudden the state walked it back, and we didn't get reunification services. Whether or not that's a legitimate claim, I dispute that being a legitimate claim.
Let me suggest that the following might be the daylight and get your reaction to it. It could have been true that the juvenile court, when it did the knowing and voluntary analysis, thought that the only thing that mother needed to know and to be voluntarily waiving, it was really the knowledge prong of it, the mother needed to know that once she entered the Rule 34E admissions, that those facts would be accepted as true. But what they're telling us is that there's a second piece to all this, that mother thought, even though I know that these facts might be true, I'm also doing this because DCFS has promised me that reunification services are going to be offered. And they're saying that those are different. The former can be true while she's still being duped on the latter. So if that's true, there's daylight. So if that's true, they can win on the 60B1 motion. Why is that wrong?
I believe that, it seems to me that the court was aware, in the motion they filed, all these allegations were raised in their motion. If you look at what the motion set aside, these are, the juvenile court was aware of the base, what they said they believed was going to happen versus what happened.
Do we have a place where the juvenile court specifically says that she wasn't duped or induced?
I don't believe that there is, but I believe it was in front of the court, at least. The arguments that they think should have been in front of the court were in front of the court.
So if it's in front of the court and then the juvenile court then doesn't rule on it, doesn't that suggest that there might be daylight, and that if we reverse this on an ineffective assistance basis, that there might be a likelihood that they'd succeed on 60B1 where even though they didn't succeed on the knowing and voluntary standard?
I think it's unlikely. Maybe there's, I don't see how we get back to the idea that there's ineffective assistance where it wasn't clear at all whether, essentially, what you're having here is, and I think Judge Orm noted, that on one side, if you decide to go to trial, it's clear what happens. If you lose, you either appeal or you don't. But somehow, if you enter admissions for the 34E, then the door is wide open, and you can come, it can be months down the road, and you can say, guess what? I got bad advice, and I want to undo everything. It can be the termination trial, apparently. You can come back, I got bad advice, let's upturn the apple cart, let's just start from the beginning again, because I don't really like the way things are going. And clearly, that's why in the criminal context too, the motions to set aside pleas are met with some suspicion. Everybody wants to, if you get to wait and see what happens and see how things go, and then after the fact, when you don't like the way things turned out, let's start again, because that really didn't go well. It couldn't be any worse. I go to trial, obviously. And I also would note, just on this record, the notion that mother reasonably believed that she was going to get services is a fantasy. She has a history dating back to 2015.
She says it under oath at the trial. Do we have any contrary testimony on that point?
Well, she may. Maybe
does anybody from DCFS say, no, we never told her that?
I don't believe there was.
So on the state of the record, the only thing we have is sworn testimony from mother saying that she thought she was going to be getting reunification services. And we also have her saying that at the Rule 34, at the hearing at which she entered the Rule 34E answers as well, right?
That's her personal subjective belief, whether it's a reasonable belief or not, is, it's another.
But wouldn't that inform a Rule 60B1 mistake analysis? If she's repeatedly saying on the record, this is why I'm entering these answers, is because I think I'm about to get reunification services? Doesn't that get her to mistake?
I mean, assume that you accept her statement as the gospel truth, doesn't, I mean.
Is there anything that rebuts it?
I guess it's, trying to think if there's, I recollection, there's not somebody's statement saying we never said that, but it's also, there's no evidence, that really, that they did either. I mean, it's just an area, it's a vacancy of it.
Let's suppose it's true. Would that be enough to satisfy Rule 60B1 in terms of a mistake analysis?
So, it's assumption that, yeah, somebody from DCFS said to mother, if you enter this.
We're not gonna ask for termination, we're gonna ask for reunification like we always have. Or we're gonna offer reunification services like we always have.
I mean, if there was clear evidence, it's other than just mother's, own self-serving statement of belief, I think that would be a
Right,
different
like,
case.
accept the premise of my
Yes.
hypo. Mother says at the hearing, and then she says it again at trial. I mean, there doesn't seem to be any dispute about this. She keeps saying, no, I entered the Rule 3040 answers because I thought I was gonna get reunification services like I always have. Let's assume that's true. Let's assume that the district court then gets to a Rule 60B1 mistake analysis, which is what they're saying should have happened here. Would mother's claim be enough to establish mistake for purposes of Rule 60B1?
I don't think it should be. I think as Judge Morton had noted, even in the context of criminal pleas, again, we're looking at even more important rights, their criminal rights. You have a belief of what you might get, but you don't know what you're gonna get necessarily. And so if every case somehow, like, I have hopes, I have expectations, I have beliefs, and those don't come to fruition, then that's all of a sudden a basis for setting aside your agreement to settle the case. That's every case. We have no finality, we have no degree of certainty in these cases.
That's why it may be that a possible answer to Judge Tenney's concern is, maybe so. Maybe if those allegations stand unrefuted, there should have been an opportunity to get that straightened out. But that would have happened as concerns ineffective assistance of counsel, either an appeal from the adjudication order or in an appeal from the denial of what can be deemed a 60B order. It can't happen months and months later in an appeal from the termination disposition.
And I would agree with that very, very much. At some point, there has to be a cutoff. It can't just be this free-floating target that anytime you become dissatisfied with the course of proceedings, let's throw counsel under the bus for something they did months prior.
Yeah, well, we can throw counsel under the bus, to use that euphemism, but any such throwing should have occurred earlier in connection with one of the other final orders, not at this point in time. At least that's what I think I understood your position, or at least the guardian's position to be.
And I would agree with that. And I do see I've used up my time, so if there are no further questions, I appreciate your time.
Thank you for the argument. And Mr. Richards, you have the final word, 3 minutes or thereabouts.
Thank you. So I wanted to address kind of what was discussed just at the end of Mr. Peterson's argument, in that the record actually does contain what DCFS stated regarding disposition. So at an October 21st, 2021 pretrial hearing, the Assistant Attorney General says, and DCFS's position is, let's get moving on the case. There's a 12-month reunification period. We're already going to be pushing on 3 or 4 months if we go to trial. At the pretrial hearing on December 8th, when parents gave their 34E answers to the amended petition, the AAG says DCFS has professional staffing on the 8th. So this was actually December 2nd. On the 8th, to talk about exactly what kind of services can take place, counsel for the state says at this point, DCFS wants to make sure that if the kids are going home, they're going home for good, that everything's taken care of. So that's record 3961, 3960, 3928 for the October 21st hearing. So this is what the parents are hearing leading up to their 34E answer, that services are going to be discussed and offered. That's what their understanding is.
Or discussed at least.
They were firmly convinced that they were going to receive services. That can't, there's nothing to contradict that in the record. So the other thing I wanted to mention is that Adjudication and disposition happen at two separate times, and that's what happened in this case. The adjudication was December 2nd, 2021. Disposition is January 5th, 2022. So that's when they find out the mistake. Oh, we're not gonna get reunification services. So the timeframe to appeal the adjudication order has now passed. And so that's part of the problem here.
Unless we take the guardian's suggestion here and we treat, and again, we disagreed on what to call it, but unless we treat that ruling in which the court denies the motion to withdraw the answer, unless we treat that as sort of, treated as if it is another round of the adjudication order, and then we allow the timeline to appeal to proceed from there. Why would that be wrong?
It's wrong because counsel's not going to appeal their own ineffectiveness, and how do you expect that to happen?
But then the response that we got from the guardian on that is, well, then you can request appointed appellate counsel at that point, so then you can have a second counsel. Why isn't that the answer there?
It's not the answer because you can't expect parents to even know that there's a problem. I mean, parents are being told, we need to withdraw your 34E, please. So, okay, let's do it. I mean, if counsel's acting deficiently, then they're not giving their clients proper advice. You can't expect a parent to just say, I want a new attorney, because my attorney's not doing what legally is proper. I mean, you can't expect a layperson to know that. And that's the problem with that argument. The last thing I wanted to mention is that we can't pick and choose which procedure we're going to use to undo this. I wish we could. I wish I could create it. I wish this court could create it and say these are weighty constitutional rights. The right to parent is fundamental, probably the oldest right that we have in this country. So there should be strict rules that go into an adjudication. The state should have to say whether they're going to offer reunification services or not, on the record, or it should be in a stipulation somewhere. So I wish that was the case, but it's not the case. We are left with the rules of civil procedure. And Rule 60B provides an avenue for relief that should have been sought and it wasn't. So,
Thank you.
Thank you all very much.
Appreciate the arguments from all counsel. We'll take the matter under advisement. And as is our custom with these family law cases, hope to have an opinion out sooner rather than later. We do our very best to move those to the front of the queue. We will next call, do you need a break?
Nope, good.
Good to go. We'll next call the matter of State versus King.